Welcome to Colonie TV, the governmental educational channel for the town of Colonie.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we welcome back Professor Vin Bonventre from Albany Law School. Professor Bonventre has been teaching at Albany Law School since 1990. In a variety of subject matters, and most currently, criminal procedure, criminal law, our state and federal court systems, and of course has spent a tremendous amount of time dealing with issues involving religious liberty and freedom. As we all know, the First Amendment of the Constitution of the United States sets forth the freedom of religion. In fact, the first line of the First Amendment of the Bill of Rights sets forth no law respecting an establishment of religion or prohibiting the free exercise thereof. Well, as we can imagine, over the course of years, the court system has continually rendered decisions involving how to interpret the application of that First Amendment provision. In fact, as recently as 1943, Justice Robert H. Jackson, a graduate of Albany Law School and a Supreme Court judge, wrote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." So certainly our United States Supreme Court in 1943 was still of the utmost mind and firm concentration that that First Amendment be held sacred. More recent court decisions, though, have suggested that the Supreme Court and possibly other state courts have taken a variety of different views on the application of this very important First Amendment right. And we are here today to consult and hear from Vin Bonventre as to the evolution of our First Amendment right. And thank you so much for coming here again.
Thank you for inviting me again.
Well, the town citizens, after they saw your last show, I received a number of contacts about having you back, and
I'm now a star in Colonie.
Well, certainly far more than the moderator is, that's for sure. And we're thrilled to have you back here.
Well, thanks.
Because most recently, you've done even a symposium on the whole notion of protecting religious freedom. And I think it's important for our viewers to first understand the nature, the historic perspective of that right in our country, going back to Jefferson and Madison, and what you see going on today, and in fact, what you see New York State court system doing in regard to religious freedom.
That's right. But Judge, you know, I mean, you start off by quoting Justice Jackson, one of the most oft-quoted lines in constitutional law. I mean, how am I going to beat that? I mean, you just can't beat that. I mean, that's just a great line.
Well, he said it, didn't he?
He did say it. He wrote it. I mean, he was one of the best stylists, if not the best stylist, in the history of the United States Supreme Court. And I use every excuse I possibly can in every course, no matter what I'm teaching, to actually quote that line. It is such a magnificent line. And, you know, that's a line which I think is very, very true to the intent of the founders, you know, and we're talking about the First Amendment, we're talking about religious free exercise in this country. We're really talking about what happened in Virginia with Thomas Jefferson and James Madison. I mean, the whole history of free exercise of religion, what we have in the First Amendment in the federal Constitution, and what we have in corresponding provisions in state constitutions are based upon what Thomas Jefferson, right, and James Madison did in Virginia. And what Justice Jackson said in West Virginia versus Barnett was very, very true to that. Unfortunately, the Supreme Court today has really moved away from Jackson's belief and has moved away from Jefferson and Madison's belief. And the United States Supreme Court is a Grand Canyon or two away from the very language of the First Amendment. Because you know the First Amendment is actually stated in absolute terms. No law prohibiting the free exercise of religion. Well, that may be impossible. There has to be some laws that religionists have to abide by. Murder laws. We're not going to allow human sacrifices, which many religions around the world have believed in since the beginning of mankind. We're not going to allow that. We know that the United States Supreme Court has not allowed polygamy. Whether they should have or not is a different story. But what we know is that regardless of the very language of the First Amendment, no law prohibiting free exercise of religion, it's only reasonable that there's got to be some limitations. And in fact, Jefferson and Madison both said that there should be a limitation when religion breaks out into overt acts that threaten the peace and security of the state, which happens to be very, very similar to the language in the New York State Constitution. So at least that. Religious free exercise beats just about everything, but not when you're talking about the gravest possible abuses or threats to the security and safety.
And your point is well taken. You're saying, look, first of all, it's the First Amendment to the Constitution. The First Amendment.
And the first thing in the First Amendment.
And the first thing in the First Amendment.
They didn't bury it.
Exactly. and the language of saying no is couched, unlike many of the other following 9 amendments to the Bill of Rights.
Well, one of the things you deal with all the time is unreasonable searches and seizures.
You bet.
Right? That gives a lot of flexibility. There's no flexibility in the First Amendment.
Says no.
We know there absolutely has to be some flexibility. But when the founders said no law, at least what they meant was no law with a very, 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 very few exceptions.
Right. We're serious on this one.
That's right. Very, very serious.
Little wiggle room.
Very little. That's the best way to put it.
Very powerful statement made by the founders.
That's right. And you know, that the case that from which you were citing Justice Jackson, that was that very famous flag salute case, West Virginia versus Barnett. And as you know, in that case, West Virginia had a law, like many states had a law at that time. We were wartime, right? They had a law requiring all students to pledge allegiance to the flag. Well, this violates the religion of the Jehovah's Witnesses because they believe you only pledge your allegiance to Jehovah, to God. So Jehovah's Witnesses refuse to pledge allegiance to the flag. The case gets up to the United States Supreme Court, which had actually ruled 2 years earlier that such laws were fine, even over religious objections. But in West Virginia versus Barnett, Justice Jackson said, yeah, patriotism is great, but we're not going to force it on anybody, especially religious objectors. And he said one of the reasons why, well, he said the reason why we have free exercise of religion in the Bill of Rights is to remove it from politics, to remove it from legislators, to remove it from voters. Free exercise of religion doesn't get to be voted on. It's a near absolute. And in this case, the government could not prove that they absolutely had to require the Jehovah's Witnesses to pledge allegiance to the flag. Otherwise, West Virginia was going to fall, or the Republic was going to fall. And so Justice Jackson and a majority of the court said, no, Jehovah's Witnesses, free exercise of religion wins in this case.
And it seems that after 1943, and as we move forward, it appears that there could be an erosion by the United States Supreme Court on that very notion. And we flash forward to 1990 with Oregon versus Smith, which appeared to take the Supreme Court in a whole new place. Is that right?
That's absolutely right. The United States Supreme Court in the Oregon versus Smith case was faced with an Oregon law that prohibited certain, illegal drugs, among which was peyote. There happened to be a Native American group in Oregon that had been using peyote for their religious rituals for hundreds of years. Now that was settled. Everybody accepted that. This was a sincere religious belief. This was a sincere, a genuine religious ritual for hundreds of years. The United States Supreme Court, speaking through Justice Scalia, well, a majority of them, said, we've never said that religious objectors are entitled to an exemption from a law that's otherwise valid, from a law that's otherwise reasonable. Well, of course, that's not true. That's not true, but the majority went ahead and they said, and therefore, unless a law is targeting a particular religion, so in other words, unless a law's purpose is to target Catholics, target Jehovah's Witnesses, target Mormons, it's perfectly fine, as long as the government can show that it's reasonable, that otherwise the law makes some sense. It beats religious free exercise. Now understand what that means. Legislation suddenly is superior to the First Amendment.
But isn't that always the litmus test for any law government makes? As long as it's reasonable, it's okay?
Yeah, that is the lowest imaginable standard under due process. Due process guarantees that the laws must make some sense whatsoever. I mean, they can't say Judge Crummey must stand on his head for 2 hours every day.
It's 1 hour at this point.
Yeah, 1 hour, it's okay, but not 2 hours.
Nope.
So the whole point that a law always has to make some sense. When you say that in order to violate somebody's religious freedom, the law has to make some sense. That's not protecting religious freedom any more than everybody has protections against ridiculous laws anyway. So the Supreme Court really stripped free exercise of religion from any protection whatsoever except for reasonable laws or laws that deliberately were discriminating against a particular religion. But those kind of laws were prohibited anyway, so free exercise of religion adds nothing.
And in that decision, too, Justice Sandra Day O'Connor concurred with the end result, but got there in a different way, which apparently, the way my thought process is, she made it more narrow rather than such a large opening that was created by Justice Scalia in the majority opinion, which now has turned the entire First Amendment upside down.
Well, it has. You're absolutely right. What Justice O'Connor said was, wait a minute, I think that the state of Oregon and other states have a pretty strong reason to prohibit drugs. And therefore, this case easily fits within, the flag salute case, the Amish cases, the Seventh-day Adventist cases where we always carved out exceptions. And we said, free exercise of religion is only beaten when there's a compelling state interest. When the government has a really, really, really strong interest, and this is the only way they can promote that interest. She says, I think that's the case with illegal drugs. You could say that the government has a very, very strong interest. She says, I don't understand why you're now saying that we don't have to go through that test to protect free exercise of religion. We've always been protecting free exercise of religion that way. And in a very nice judge-speak way, she called Scalia a liar. She said, we've got all these cases. She quotes from Justice Jackson, just like you did, right?
Sure.
So you've got good company. She quotes from Justice Jackson, says, okay, do you remember that? Do you remember Wisconsin versus Yoder? Do you remember Sherbert versus Werner? And she lists all these cases where the Supreme Court said, of course, only the gravest abuses beat free exercise of religion. So she concurred, but she did not agree with his reasoning at all. And then 3 other justices disagreed with his reasoning, and they actually held in favor of free exercise of religion.
Do you find that historically the cases involving this challenges concerning the application of the First Amendment often were suffered by minority religions?
Yeah, absolutely. The country had a pretty abominable record with regard to religious free exercise early on. Other than for Protestant Christians, it had a pretty bad record. And that included the United States Supreme Court. I mean, the way the United States Supreme Court treated Mormons was absolutely dreadful. I mean, the Mormons believed in polygamy. That was part of their religion. And so the United States Supreme Court said, well, everybody of every common sense knows that polygamy is bad. Well, everybody doesn't think that
In
that's
fact,
the case.
didn't they use the word odious
Yes,
in the decision?
odious.
Right.
Not only that, they said that. They said Mormonism, Church of Latter-day Saints, they said that wasn't even a religion. They said that was a cult. So they took away their right to vote, right? They were going to take away their citizenship. They were going to take away their right to own land. And in fact, they even dissolved the Church of Latter-day Saints. And then they weren't too crazy about the Quakers either, because the Quakers were pacifists. They've never been particularly good about the Jews. In fact, not too long ago, you had this Orthodox Jewish rabbi. This is Goldman versus Weinberger. Orthodox Jewish rabbi, right? And he's in the Air Force. He wears his yarmulke, right? He wears his yarmulke. And one day, for whatever reason, he must have annoyed somebody in the command. But all of a sudden, one day, after having worn his yarmulke all the time, the commander decided, well, you're out of uniform. And he says, but wait a minute, I've been wearing the yarmulke, and I'm required to wear my yarmulke. They say, no, you're out of uniform. And so what they did was, they court-martialed him. They said they were going to court-martial him. The case gets up to the United States Supreme Court. And the United States Supreme Court, and this was immediately before Oregon versus Smith, so you could see there was this erosion happening. The United States Supreme Court said, well, we're going to defer to the military. This is a matter of discipline. Oh, give me a break. The guy's been wearing his yarmulke for a long time. Nobody bothered with it. It never offended anybody whatsoever. Now, the Jews have not fared very well at the United States Supreme Court. The Jehovah's Witnesses always do well. In fact, when I was studying my PhD, studying religious freedom, the standard was Mormons lose, Jehovah's Witnesses win. They win in the leafleting cases. They win in the flag salute cases. They win in those cases where they're on the street and saying that Catholics are Satan, and the Catholics get all upset about it. No, Jehovah's Witnesses almost always win.
Subsequent to Oregon versus Smith,
Right.
which seemed to be a different view of the First Amendment than
Sure was.
as Justice Jackson's view
Boy,
in
was it.
1943, so that it essentially now almost leaves it to each state to
That's right.
decide the level of application of the First Amendment. Is that true?
You're absolutely right, because Oregon versus Smith, by and large, see, the United States Supreme Court can't tell states what to do unless states are violating the federal Constitution. What they can only say is this does offend or does not offend the federal Constitution. So what they said in Oregon versus Smith is that restrictions on religious liberty do not offend the federal Constitution unless the law is asinine, all right? So that leaves it up to the states. If the states want to protect religious liberty, they can continue with the very strict protections that Justice Jackson was giving to religious liberty. And some of the states have done that. Wisconsin has done it. The state of Washington has done that. The state of Minnesota has done that. And what these states have done is when they have a law that interferes with religious freedom. So, for example, one of the states, one of the cases, several of them involve the Amish. You know, many states require that these slow-moving vehicles attach to the back of their vehicles these brightly colored triangles. That offends the religious beliefs of the Amish, right? Some of the states, like Kentucky, which have gone along with Justice Scalia, they say, too bad, Amish, you've got to violate your religion. You've got to put that triangle on the back of your carriage. Other states like Minnesota and Wisconsin, they say, no, we're serious about religious free exercise in this state. So, state, you come up with some other safety precaution that does not offend the Amish. So the Amish don't have to use that triangle. They could use something else.
And another example of how states are taking this on in their own way.
Right.
California adjudicated a case in one way about cohabitation, and
Right.
Minnesota might have taken a different approach. Would you tell us a little bit about that?
Sure. In both these cases that you're talking about, what happened, you had landlords that did not want to rent to unmarried couples because they knew what the unmarried couples were going to be doing. And in both cases, the landlord said, we do not want to be facilitating what we think to be sin. Okay, I mean, that's not a terribly controversial religious belief, but it certainly does get in the way of the enforcement of some, equal housing laws. California said, well, we're going to apply Oregon versus Smith. The law seems perfectly reasonable that you can't discriminate against who you rent to. So landlord, you and your religious beliefs lose. In Minnesota, however, Minnesota said, well, we think equal housing laws are important. But there is religious free exercise. And we think, unless the government can show us that this is the only way this unmarried couple can get an apartment, we are going to protect the religious freedom, right, of this landlord. So two very different results, depending upon whether they go along with Justice Scalia, Oregon versus Smith, or basically if they go along with Justice Jackson in West Virginia versus Barnett.
Are there any positives, in your opinion, about really the Supreme Court in 1990 defaulting now on this issue to the states? Will there be any positive outcomes, in your opinion, or does it just provide for a patchwork of different application? Is that troublesome, or does it give people more choices at the state level to choose the state they want to live in with the types of application of law that they have in that particular state?
Yeah, I personally don't think there's anything positive about Oregon versus Smith. And the reason for that is, yes, it does give states a lot of leeway, which I always think is good.
Right.
I always think it's good. I don't think that's good, however, when you're talking about fundamental rights. I don't want to give states the leeway to discriminate on the basis of race. Right. I don't want to give states the leeway to engage in unreasonable searches. And I don't want to give states the leeway to violate free exercise of religion.
Right.
And you don't have to be a believer. I'm not. But freedom of conscience, freedom of worship, freedom to believe in and to act upon your most sincere and devout beliefs, that's the essence of what we mean by a free society. And Oregon versus Smith really has diluted that.
In New York State, have there been recent cases or application or challenges involving even our own state protection on this issue?
Yes, there have been. Earlier on in 1943, People versus Barber, Irving Lehman, when he was chief judge, he said, the United States Constitution and the Supreme Court might be protective of free exercise of religion. In New York, we're even more protective. And in that case, he actually protected the Jehovah's Witnesses even more than the Supreme Court was willing to do at the time. Actually, the Supreme Court followed the New York Court of Appeals and Chief Judge Irving Lehman the very next year. In the flag salute case, they followed the New York Court of Appeals in the flag salute case. Unfortunately, today what has happened is, because of Oregon versus Smith, the New York Court of Appeals is not required to apply that very, very strict test to apply free exercise of religion. So the Court of Appeals has chosen not to do so. The Court of Appeals in Catholic Charities versus Serio, when Catholic Charities was complaining about the requirement in New York law that Catholic Charities has to provide health care coverage that includes contraception, Catholic Charities objected to that. They say, look, that's against the Catholic religion, contraception. The New York Court of Appeals said, well, we won't go along with Oregon versus Smith, but then the New York Court of Appeals adopted for New York a test that's even worse. The New York Court of Appeals said, if there is a law that infringes upon your free exercise of religion, you might be able to win, but only if you prove that the law is unreasonable. At least in Oregon versus Smith, Scalia said the government had to prove that its law was reasonable. In New York, when somebody's free exercise of religion is being violated under Catholic Charities versus Serio, the religious objectors got to prove that the law is unreasonable. So it's pretty awful. But to tell you the truth, I don't think the Court of Appeals is going to follow that decision. I don't think they're going to follow that decision. I don't think they took the case and the issue seriously enough. When we have a tougher closer issue, I think the Court of Appeals is going to say, well, we didn't mean that. I'm pretty sure about that.
Well, you know, it seems like a far cry from the language in the First Amendment.
Isn't it? Yes.
It says no law respecting an
law.
establishment of religion or prohibiting the free exercise thereof. And now what you have in a most recent Court of Appeals decision that you've cited, based on your analysis of that decision, it's, but the person who is trying to exercise their religious freedom must now have the burden of proof to show that the otherwise. That they have the burden of proof is shifted from government to the individual.
And we're not talking about the individual proving that this violates his religion. That's already a given. We're talking about the individual saying, yes, we all agree my religion is being violated. I've now got to prove that the law is unreasonable.
Vin Bonventre, once again, you have lit up the board here on Benchmark and brought us another very important topic for all of us to consider, and the evolution of our United States Constitution and our state constitution, and most importantly, how our courts have been interpreting both of those over the hundreds of years. And it's so important for all of us to recognize this in our day-to-day lives, that while we're moving forward with what we're doing every day, there's also there's an overview that our court system routinely is impacting, and which can involve the rights of the citizens of the state of New York and of the town of Colonie.
Thank you so much for inviting me again.
Well, we're thrilled that you've come here again, and we look forward to seeing you down at Albany Law School once again. I'm Colonie Town Judge Peter Crummey, and thank you for joining me on Benchmark.